The courtroom was already full when my name was called. Not the kind of full you see on TV, with reporters and flashing cameras. This was worse. Local attorneys, a few extended relatives, 2 neighbors who suddenly cared about probate law, and my parents sitting in the second row like they had front row tickets to something entertaining. I stood at the defense table alone. Across from me, my parents' attorney adjusted his glasses and organized a stack of printed photos. He looked relaxed, confident, like he'd already decided how this would end. The case sounded simple on paper. My grandfather, Colonel James Grant, retired U.S. Army, left the majority of his estate, about $5.2 million, to me, his only granddaughter. He left very little to his son and daughter-in-law, my parents. They were contesting the will. Their claim was even simpler. I wasn't capable of managing that kind of money, and apparently they had proof. Their attorney stepped forward and asked permission to display exhibits. The judge nodded. A large monitor beside the bench flickered to life. The first image filled the screen. Me, in a navy apron, hair tied back, carrying 2 coffee mugs. A timestamp sat in the corner. The courtroom got quiet in that uncomfortable way people do when they recognize someone in a position they weren't expecting. The second photo appeared. Me again. Behind a counter this time, smiling at someone off camera. The third, wiping down a table. My parents didn't look at me. They looked at the screen. Their attorney began speaking in a calm, reasonable tone. These photos were taken over a 3-week period, he said. Miss Grant appears to be employed at this cafe on a consistent basis. He let that sit. Then he added, Your Honor, managing a multi-million-dollar estate requires financial sophistication, stability, and judgment. He didn't say the rest out loud. He didn't need to. The implication floated around the room like cheap perfume. The judge leaned back slightly. Middle-aged, gray hair, experienced. The kind of expression that says he believes he's already seen everything. He looked at me over his glasses. Miss Grant, he said, Are you currently employed at a coffee shop? His tone wasn't hostile. It was worse. It was dismissive. Yes, Your Honor, I answered. A small shift ran through the gallery. My parents' attorney nodded as if I'd just handed him a gift. The judge tapped a pen against his notepad. And you are aware, he continued, that this proceeding concerns the management of approximately $5.2 million. Yes, Your Honor. He paused. Then he smiled slightly. Managing millions is a bit different from serving coffee, Miss Grant. The words were calm, measured, and designed to land. They did. Laughter broke out in the back of the room. Not loud, not wild, just enough. A few people tried to hide it. A couple didn't bother. My mother covered her mouth, but her shoulders were shaking. My father didn't even try to pretend. He laughed openly. That part didn't surprise me. What surprised me was how comfortable they looked, like they'd finally found proof of something they'd believed about me for years. The judge continued, flipping through the photos. These images, he said, raise legitimate questions about financial capacity. Financial capacity. Because I wore an apron. Because I carried coffee. My parents' attorney stepped forward again. We believe the decedent may have been influenced by emotional manipulation, he said, and that Miss Grant's current employment reflects limited financial experience. Limited financial experience. I had to look down for a second, not out of shame, just to keep my expression neutral. The judge turned back to me. Miss Grant, have you managed assets of this size before? No, Your Honor. Technically true. He nodded slowly as if that confirmed everything he needed. Behind me, I heard my mother whisper something to my father. He chuckled again. I focused on the edge of the defense table and kept my breathing steady. The attorney continued outlining their theory. I had allegedly isolated my grandfather in his final months. I had supposedly positioned myself to receive preferential treatment. And now, based on visual evidence, I was clearly working in a service position inconsistent with complex estate management. Service position. That phrase lingered. The judge adjusted in his seat. This court deals with serious estates, he said. Not part-time cafe workers trying to learn on the job. More laughter. The judge didn't reprimand anyone. He let it happen. He turned toward me again. Do you have representation today, Miss Grant? I am representing myself, Your Honor. Another shift in the room. The attorney across from me looked almost sympathetic. Almost. That is your right, the judge said carefully. Though I would strongly suggest obtaining counsel given the complexity of the matter. Complexity. It was interesting hearing that word used like a warning. My parents' attorney began summarizing their request. They wanted the will declared invalid. They wanted the estate placed under supervised administration. They wanted a psychological evaluation. That part drew a reaction from a few people. Psychological evaluation, because I worked at a cafe. The judge nodded slowly, writing something down. I didn't interrupt. I didn't object. I didn't correct a single assumption. When the attorney finished, the judge folded his hands. Miss Grant, he said, this court needs assurance that the decedent's estate is not being placed in inexperienced hands. Inexperienced. The word hung there. I could feel every pair of eyes in the room waiting for me to fumble, to explain myself, to defend the apron, to justify the coffee. My parents were both smiling now, not cruelly, just confidently, like they had finally reduced the story to something simple enough for everyone else to understand. The girl they sent away, the granddaughter who ended up serving drinks. $5.2 million. The contrast was funny to them. I reached down and picked up the folder I'd brought with me. It wasn't thick, just organized. I stepped forward. Your Honor, I said evenly, may I respond to the court's concerns regarding my financial capacity? The room grew quiet again. The judge nodded once. Briefly, he said, I looked at the monitor where my photo was still frozen on the screen apron coffee mug's timestamp. Then I looked back at the bench. Yes, Your Honor, I said. I kept my eyes on the judge, but for a split second, I saw my grandfather standing in the doorway of his old study, arms crossed, waiting to see whether I would fold or hold. I was 8 the day my parents dropped me off at his house with 2 suitcases and a plastic storage bin full of clothes that didn't fit. They called it a better opportunity. What it meant was simpler. I was inconvenient. My father had just started a new job that required travel. My mother said the house was too small for tension. I remember that word clearly. Tension. Like I was a loose wire sparking in the corner. My grandfather opened the front door in a pressed button-down shirt and khakis. Even retired, he looked like he was 5 minutes away from briefing a battalion. He didn't hug me. He didn't kneel down and ask how I felt. He looked at my parents and asked one question. Is this permanent? My mother said, just until things stabilize. He nodded once. That was it. They left 10 minutes later. No dramatic goodbye. No tears. Just taillights disappearing down a quiet Virginia street. That night, my grandfather handed me a printed schedule. Wake up 5:30 a.m. Bed made by 5:35. Breakfast at 6 o'clock. Reading hour at 6:30. I stared at it like it was a foreign language. He noticed. You want structure, he said. You just don't know it yet. I didn't argue. Under his roof, you didn't argue without facts. Life with Colonel James Grant was not warm. It was steady. He believed in 3 things: discipline, accountability, and earning your place in any room you entered. If I forgot to do something, there was no yelling. Just consequences. If I complained about homework, he sat me at the dining table and worked through logic problems with me until I stopped complaining. If I said something wasn't fair, he asked, is it illegal? That question stuck. By the time I was 12, I knew the difference between fairness and legality. By 14, I was reading basic contract law at his suggestion. People misunderstand paperwork, he told me once. Paperwork doesn't misunderstand people. My parents visited occasionally, birthdays sometimes, holidays if it didn't conflict with travel plans. They always commented on how serious I seemed. My mother once laughed and said Dad turned her into a little soldier. My grandfather didn't smile. She turned herself into one, he replied. When I was 16, I overheard a conversation in his office. My parents were arguing with him. They wanted early access to part of his investment portfolio. Something about a real estate opportunity. Something about leverage. He refused. After they left, he found me sitting on the back steps. You heard that, he said. I nodded. They believe inheritance is entitlement, he continued. It's not. He sat down beside me, which he rarely did. Responsibility isn't inherited, he said. It's proven. I didn't know then how literal that statement would become. In college, I chose law, not because of drama. Not because I liked arguing. Because I liked clarity. Rules, structures, systems that made sense if you studied them long enough. My parents told relatives I was still figuring things out. They rarely asked about classes. When I mentioned internships, they changed the subject to market trends and vacation properties. After graduation, I applied to the Army. Not out of rebellion, not out of desperation, out of alignment. Structure made sense to me. Service made sense. Accountability made sense. Officer candidate school was the first place I felt completely understood without explaining myself. No one cared who my parents were. No one cared what house I grew up in. They cared whether I showed up prepared. Law school through the Army came next. Long nights, case briefs, military justice, estate disputes, administrative investigations. I found I had a strange advantage in probate law. I'd grown up watching adults treat money like oxygen. I understood how emotional it made people. As a JAG officer, I handled cases involving family disputes over survivor benefits. I advised commanders on legal exposure. I reviewed contracts that made my parents' real estate arguments look amateur. Through all of it, my grandfather never once bragged about me. He just asked questions. What did you miss? What would you do differently? Did you earn the trust of the room? When he got sick, he didn't tell anyone at first. I noticed because he stopped waking up at 5:30. That was how I knew something was wrong. Hospital visits were quiet. No dramatics, no speeches. One afternoon, he asked me to bring a folder from his desk. It was thick, organized, tabs labeled clearly. Estate documents. I updated it, he said. I didn't ask why. He didn't explain immediately. He just looked at me for a long time. Money amplifies character, he said finally. It doesn't create it. I nodded. He closed the folder. If you receive this, it will not be because you are my granddaughter, he continued. It will be because you are the only one in this family who understands stewardship. He never used the word love. That was his version of it. When the will was read months later, the room felt smaller than the courtroom I was standing in now. My parents sat stiffly while the attorney read numbers out loud. $5.2 million in total assets. The majority allocated to me. A modest sum to them. Silence. My mother blinked rapidly. My father's jaw tightened. The attorney cleared his throat and continued reading the clause, explaining the reasoning capacity, confidence, long-term management. My parents didn't look at me. They looked at each other, like they were recalculating something. That was the day I stopped being background noise in their lives. That was the day I became an obstacle. I stayed composed at the reading. I thanked the attorney. I went home. 2 weeks later, I was served with legal papers. Petition to contest the will. Grounds: undue influence. Questionable capacity. Financial instability. Financial instability. I stood in my kitchen holding the envelope and let out a short breath that almost sounded like a laugh. If my grandfather had been there, he would have asked only one question. Are they wrong? I folded the petition neatly, set it on the counter, and reached for my phone. I scrolled to my commander's number and pressed call before I could overthink it. He answered on the second ring. Grant. Sir, I need to self-report a civil matter. There was a short pause. Not alarmed, just attentive. Go ahead. My parents have filed a petition to contest my grandfather's will. It involves approximately $5.2 million. I'm named primary beneficiary. Another pause. Longer this time. Is there any allegation of misconduct on your part? Yes, sir. They're claiming undue influence and financial instability. That word again. Financial instability. All right, he said evenly. You did the right thing by reporting it immediately. Send me the paperwork. Loop in legal assistance for guidance. And update your security manager. Yes, sir. No lecture. No suspicion. Just process. That's the difference between emotion and procedure. Within 24 hours, I had emailed the petition to my brigade legal office and scheduled a meeting with the security manager responsible for my clearance file. Large financial events require disclosure when you hold a clearance, especially at my level. It isn't optional. It's preventative. The meeting was in a beige office with 2 metal filing cabinets and a framed American flag print that had probably been there since 1998. The security manager read through the petition carefully. They're alleging instability, he said. Yes. Any debt issues? Gambling delinquent accounts. Number. He nodded. As long as this is a family probate dispute and not evidence of misconduct, it's unlikely to affect your clearance. But document everything. Document everything. That phrase felt familiar. I left the building with 2 parallel tracks running in my head. Track 1, defend the will. Track 2, protect my career. My parents, meanwhile, were running a very different strategy. The petition itself was aggressive. They alleged that my grandfather had been isolated from meaningful familial input. They claimed I had positioned myself as sole advisor during a period of declining health. They questioned his mental capacity during the final amendment of the will. And then almost casually, they inserted the phrase, "Respondent is currently employed in a low-wage service position inconsistent with the management of complex financial assets." Low-wage service position. They hadn't even seen the photos yet. They were building the narrative first. The photos would just decorate it. A week later, I received an email from an extended relative asking if everything was okay. That's when I realized my parents weren't keeping this quiet. By the end of that month, 2 more family members reached out with variations of the same question. I heard you're going through something. I didn't know you were struggling. Struggling. The word traveled fast. I met with a civilian probate attorney to review the case. I wasn't going to represent myself in filings. That would be reckless. He skimmed the petition and leaned back in his chair. This isn't about money, he said. It's about control. I'm aware. They're going to try to paint you as inexperienced or unstable. That's their angle, I assumed. He nodded slowly. Are you currently working anywhere outside the Army? Yes. What kind of work? Coffee shop. A friend owns it. He raised an eyebrow. That will be used against you. I figured. He studied me for a moment. You don't seem concerned. I am, I said. Just not about that. The truth was simple. I was on transitional leave between assignments after completing a deployment cycle. My next duty station orders were pending. During that gap, my access to certain financial accounts tied to the estate was temporarily restricted as part of routine compliance review. Large inheritance plus active duty officer equals scrutiny. That's not drama. That's policy. So instead of sitting in my apartment refreshing investment dashboards, I couldn't touch yet. I helped my friend Lauren at her cafe. 3 shifts a week, cash register, cleaning tables, pouring lattes. It kept me busy. It kept me normal. Apparently, it also made me legally incompetent. One afternoon, Lauren walked over holding her phone. There's a guy outside taking pictures, she said. Of what? You. I glanced toward the front window. A man leaning against a sedan, pretending to check his phone while angling the camera. Private investigator. That escalated quickly. I walked outside. He didn't hide. Can I help you? I asked. I'm just documenting public activity, he said. For whom? No comment. Of course. I nodded once and went back inside. Lauren looked nervous. Is this bad? Not unless they're allergic to coffee. She didn't laugh. Over the next 2 weeks, the same car appeared multiple times. Different parking spots. Same driver. I didn't change anything. I wore the apron. I clocked in. I wiped tables. If someone wants a story, you don't panic. You let them write it exactly as they planned. Meanwhile, my parents' attorney filed a motion requesting financial oversight of the estate pending litigation. Their argument: immediate risk of mismanagement. My probate attorney forwarded me the filing with one sentence attached. They're pushing hard. I read it carefully. The language was polished, concerned, protective of my grandfather's legacy. It almost sounded noble. What it actually said was, this frees her authority. That was the real goal. Control the estate before trial. Control the narrative before facts. At the next preliminary hearing, their attorney referenced employment records and community observations. Community observations. That's a polite way of saying gossip. The judge scheduled a formal evidentiary hearing. That's when the photos would come in. That's when the apron would officially matter. 2 nights before the hearing, my mother called. I let it ring. She left a voicemail. We don't want to embarrass you, she said. But this can still be handled privately if you're reasonable. Reasonable, meaning surrender. I deleted the message. The morning of the hearing, I put on a navy suit instead of the apron. It felt heavier, more expected. I reviewed the petition again in my car before walking inside. $5.2 million. Undue influence. Financial instability. Low-wage service position. The language was consistent. Strategic. Predictable. What wasn't predictable was how easily people accept a story when it fits their assumptions. Inside the courtroom, my parents sat confidently behind their attorney. The private investigator was there too. I took my seat at the defense table. The judge adjusted his glasses. Counsel, he said, you may proceed. And that's when the monitor lit up with the first photograph. The first photo stayed on the screen longer than it needed to. The private investigator was sworn in and took the stand like this was a routine insurance dispute. He stated his name, his license number, and his years of experience. Were you retained to observe the respondent? My parents' attorney asked. Yes. For how long? Approximately 3 weeks. And during that time, what did you observe? He glanced briefly in my direction. I observed Miss Grant working at a cafe located on Brook Street. She appeared to perform standard employee duties, serving customers, cleaning tables, operating a register. The attorney nodded. How frequently did you observe her? Roughly 3 to 4 times per week. Consistent employment. That was the phrase they wanted the court to hear without actually saying it. The attorney clicked to the next image. Would you describe what we're seeing here? Miss Grant in an apron carrying beverages to customers. Another click. And here, behind the counter, the attorney turned toward the bench. Your Honor, this is not a single incidental shift. This is regular employment in a low-wage service environment. Low wage again. They liked that one. The judge leaned forward slightly. Miss Grant, he said, are these photographs accurate? Yes, Your Honor. And you are not disputing that you have been working there? No, Your Honor. The investigator remained composed like he'd done his job well. Technically, he had. He documented exactly what was visible. What he didn't document was intent, or context, or the fact that part-time work during transitional leave is not a federal offense. My parents' attorney shifted to a softer tone. Your Honor, estate management requires financial literacy experience with investment vehicles and decision-making under pressure. He gestured lightly toward the screen. Respondent's current employment history does not reflect such experience. Employment history? He didn't ask about education. He didn't ask about military service. He didn't ask about professional background, because the story worked better without those details. The judge wrote something down. Miss Grant. He said, what is your annual income from this cafe? Variable, I replied. It's part-time. Ballpark. Under $20,000 annually, Your Honor. A faint reaction in the room. Under $20,000. $5.2 million. The math looked embarrassing if you didn't know anything else. The attorney nodded with quiet satisfaction. No further questions for this witness. The investigator stepped down. My attorney wasn't objecting. Not yet. He'd warned me about this. They're building perception, he said earlier. Let them overcommit. The judge turned toward me. Miss Grant, you may cross-examine. I stood. The investigator adjusted in his chair again. Mr. Daniels. I began evenly during your observation period. Did you ever enter the cafe? Number. Did you request employment records? Number. Did you speak with this business owner? Number. So your conclusion that I am employed consistently is based solely on visual observation from a public sidewalk? Yes. And you did not investigate whether I hold any other professional position? Number. Did you verify whether I am on active duty with the United States Army? The courtroom shifted slightly. The investigator hesitated. Number. Did you check any public records regarding my professional licensing or bar admission? Number. Did you review my financial statements? Number. So your report contains no information about my education, my military service, my legal qualifications, or my financial training? That is correct. I nodded once. No further questions. I sat down. The damage wasn't undone, but it was framed. My parents' attorney rose again. Your Honor. Even without deeper investigation, the optics are clear. The decedent entrusted significant wealth to an individual currently working in an entry-level service position. Optics. That word always shows up when facts are thin. He continued. We are not attacking respondent's character. We are questioning her capacity. My mother nodded slightly at that. Capacity sounded clinical, responsible, almost caring. The judge folded his hands. Miss Grant. Do you have evidence today of your financial qualifications? I do, Your Honor. Then you may present it after we address the petition's broader claims. Broader claims. That's where they shifted next. Undue influence. Isolation. They called a family friend who testified that my grandfather had seemed distant in his final year. They suggested I limited access. They implied I positioned myself as sole advisor. None of it was supported by documentation. But probate court isn't about dramatic evidence. It's about creating doubt. My attorney objected where appropriate. The judge sustained some, overruled others. The room stayed engaged. People like watching family disputes when there's money involved. It feels educational. At one point, my parents' attorney said, Your Honor, the pattern here suggests dependency rather than leadership. Dependency, that one was new. The judge leaned back again. Miss Grant, he said, did you rely financially on the decedent prior to his passing? No, Your Honor. Were you receiving regular transfers? Number. Did you have independent income? Yes. He glanced at the screen again. From the cafe. The gallery chuckled softly. I didn't look back this time. Yes, Your Honor, I said. That answer landed exactly how they wanted it to. The attorney requested temporary supervisory control over the estate pending final ruling. He framed it as precautionary. Given the circumstances, the risk of mismanagement is non-trivial. Non-trivial. They were trying to freeze me out before the case even moved forward. My attorney leaned toward me and whispered, We respond fully now. I nodded. The judge looked at me. Miss Grant, he said, this court requires assurance that the estate is not placed in inexperienced hands. Inexperienced again. The word circled back. The monitor still showed me in an apron smiling at someone off frame. The story looked simple. Girl serving coffee. Sudden inheritance. Concerned parents. Prudent court. I stood slowly. Your Honor, I said with the court's permission, I would like to clarify my professional background and address the issue of financial capacity directly. The judge studied me for a moment, then he nodded. Proceed. I placed a thin stack of documents on the defense table, but kept my hand on them instead of sliding them forward. Before I address financial capacity, I said I'd like to respond to the implication of instability. My parents' attorney shifted slightly. The judge nodded. Go ahead. I kept my voice steady. The petition filed by the plaintiffs includes language suggesting emotional manipulation dependency and impaired judgment. It also requests consideration of a psychological evaluation. The word evaluation floated in the air like something clinical and polite. My mother looked straight ahead. My father avoided eye contact. The attorney stood. Your Honor, we're not diagnosing. We're requesting due diligence. Due diligence, another phrase that sounds responsible while quietly cutting someone down. I continued, I have never been diagnosed with any mental health disorder that impairs my judgment. I have never been subject to disciplinary action in any professional setting. I hold an active security clearance with the United States Army. That line changed the temperature in the room by a few degrees. Not dramatically, but noticeably. The judge looked up. Security clearance. Yes, Your Honor. The plaintiff's attorney stepped in quickly. Clearance status is not evidence of a state management capability. No, I replied evenly, but it is evidence of financial and personal stability under federal review. Silence. Clearances aren't handed out casually, especially not to people who can't manage their lives. The judge leaned forward slightly. What level of clearance do you hold? I paused for half a second. Secret, Your Honor. I didn't elaborate. I didn't mention periodic reinvestigations. I didn't mention financial audits. I didn't mention mandatory reporting. I let the words stand alone. The attorney tried to pivot. Your Honor, clearance does not equate to wealth management expertise. Agreed, I said, but it contradicts the narrative of instability. He didn't like that. He turned to a new angle. Miss Grant, have you ever undergone counseling? There it was. Weaponized normalcy. Yes, I answered. A ripple in the gallery. Following deployment. That stopped the ripple. Military counseling after deployment is standard. Responsible. Expected. The attorney hesitated. Was that voluntary? Yes. Was it required? Yes. The judge interjected. That is not evidence of incapacity. The attorney nodded, adjusting. We're simply establishing a complete picture. Complete picture. So far, their complete picture consisted of coffee mugs and therapy sessions. My attorney stood. Your Honor, the implication here is damaging. Suggesting psychological instability without evidence is improper. The judge looked thoughtful, but didn't reprimand anyone. Instead, he turned back to me. Miss Grant, are there any pending disciplinary matters in your military record? No, Your Honor. Any financial delinquencies? Number. Any bankruptcy filings? Number. The plaintiff's attorney shifted again. Your Honor, even absent formal discipline. We are concerned about her current employment reflecting diminished earning capacity. Diminished earning capacity. That was new phrasing for the same idea. I spoke before my attorney could. My current part-time work does not reflect my long-term earning capacity. And what is your long-term earning capacity? The attorney asked. There was a tone there now. Slightly sharper. Substantially higher than cafe wages. A few restrained smiles in the room. The judge tapped his pen. Miss Grant, you indicated you have additional documentation. Yes, Your Honor. I slid one document forward. It wasn't flashy, just official letterhead. Active duty orders. The attorney glanced at it. Relevance, he asked. Establishing employment status. My attorney responded. The judge read the first page quietly. His eyebrows shifted just slightly. He flipped to the second page. Then he looked up at me. You are currently on transitional leave. Yes, Your Honor. Between assignments? Yes. And the cafe work is temporary? Yes. The plaintiff's attorney stepped in again. Temporary or not, it reflects current circumstances. Current circumstances do not negate professional credentials, my attorney replied. The courtroom energy was shifting, not dramatically, but enough that my parents stopped smiling. The attorney made one more attempt. Your Honor, estate administration involves investments, tax planning, fiduciary duties. It is not entry-level work. No, I said calmly. It is not. He paused. Then explain why you are the most qualified individual in this room to manage it. That question wasn't for information. It was for spectacle. The judge didn't stop him. The room got quiet again. My parents leaned forward slightly. They wanted this. They wanted me boxed into something small. I kept my posture relaxed. Because I understand fiduciary duty, I said. In what context, he pressed. In legal context. The attorney smiled faintly. And where did you acquire that legal understanding? There it was. The opening. The one they didn't realize they'd created. I felt my heartbeat slow instead of speed up. Years of courtroom exposure do that to you. You don't rise to volume. You lower it. I acquired it through formal legal training and professional practice, I said. The judge looked curious now. Professional practice as what, Miss Grant? My parents were watching closely. This was the moment they believed would confirm their version. The attorney crossed his arms slightly. The gallery leaned in. I placed my second document on the table, but didn't slide it forward yet. I believe that clarification addresses both financial capacity and alleged instability, I said evenly. The judge nodded once, then clarify. I slid the second document forward and let it rest between us. My professional practice, I said, is as a licensed attorney. The room didn't react immediately. People process information in layers. First surprise, then recalculation. The plaintiff's attorney blinked once. Licensed. Where? Commonwealth of Virginia. The judge looked down at the document in front of him. Bar number. Active status. No disciplinary record. And your current employment, he asked. I am an active duty officer in the United States Army. That landed harder. Not dramatic, just quiet. The kind of quiet where people sit up straighter. In what capacity, the judge asked. As a judge advocate, Your Honor. The plaintiff's attorney let out a short breath that almost sounded like a laugh. A military lawyer. Yes. The judge's expression shifted slightly. Not impressed. Not dismissive. Evaluating. And you chose not to disclose this earlier, he asked. I was not asked about my professional background until today. The attorney cut in. Your Honor. This is irrelevant to estate management. Military legal work is not the same as private fiduciary practice. I kept my eyes on the bench. Your Honor, as a judge advocate, I advise on administrative investigations, financial liability, matters, contractual disputes, and statutory compliance. I routinely review documents with legal and financial consequences exceeding the value of this estate. That was factual, measured, no exaggeration. The judge tapped the document again. You are currently on transitional leave. Yes, Your Honor. And instead of practicing law during this period, you are serving coffee. Yes. A faint ripple of amusement moved through the room again. The judge leaned back. Why? Because I felt like it wasn't going to satisfy him. Because I completed a deployment cycle, I said. Because I am between duty assignments. Because assisting a friend part-time is lawful and temporary. The plaintiff's attorney stepped forward again. Your Honor. Even accepting her military position, the optics remain troubling. A multi-million-dollar estate requires full-time attention and specialized financial management. Optics, the judge repeated almost absently. He looked at me again. Miss Grant, do you have experience specifically administering estates? Yes, Your Honor. In what capacity? As legal advisor to service members navigating probate matters and beneficiary disputes. The attorney smiled thinly. Advising is not the same as managing. Correct, I said. Which is why estates often retain financial advisors. Management does not require personal day trading expertise. It requires fiduciary duty oversight and compliance. The judge's pen paused mid-note. The plaintiff's attorney sensed the shift and pivoted quickly. Your Honor. Even if respondent is legally trained, her current conduct reflects questionable judgment. Working in a cafe while under review for estate control. I am not under review for misconduct, I said calmly. He ignored that. Demonstrates a lack of seriousness. There it was. Not illegal. Not incompetent. Not unstable. Not serious. The judge looked directly at me. Miss Grant, perception matters in fiduciary roles. Yes, Your Honor. And you understand why this court might view your current employment as inconsistent with estate stewardship. I understand the perception, I replied. I do not agree that it reflects my qualifications. The judge's tone shifted subtly. This court deals with complex estates regularly. We do not hand them over lightly. A service position, he paused briefly, is not typically associated with high-level financial administration. There it was again. Service position. Not illegal, just inferior. Behind me I heard a soft chuckle. My father this time. My mother leaned toward him and whispered something. The judge didn't correct the laughter. He continued, if this were simply a dispute among equals, that would be one thing. But the visual evidence presented today suggests a gap between responsibility and experience. Visual evidence. He was leaning into it, not facts. not credentials. Visual narrative. I stood very still. As a reminder, I said evenly, visual evidence does not constitute proof of incompetence. The plaintiff's attorney objected lightly. Argumentative. Sustained, the judge said, though his tone lacked force. He folded his hands again. Miss Grant managing millions is a bit different from serving coffee. This time he didn't smile. He didn't need to. The sentence echoed. There was no full laughter now, just murmurs. The message had landed earlier. He added, the court must consider whether the decedent exercised sound judgment in designating you as primary beneficiary. There it was. Not just my capacity, my grandfather's. My attorney stood quickly. Your Honor. That statement approaches a presumption of incompetence without evidentiary basis. The judge looked mildly irritated. I am evaluating credibility. With respect, my attorney replied, linking part-time cafe work to diminished capacity may reflect bias rather than legal analysis. The word bias hung there longer than anything else had. The courtroom went very quiet. The plaintiff's attorney stepped in immediately. We object to any suggestion of judicial bias. The judge straightened. I am not biased, he said evenly. I am cautious. Caution is appropriate, my attorney responded. Assumption is not. The temperature in the room changed. Subtle, but real. The judge glanced again at the monitor still displaying me in an apron. He looked at the bar certification in front of him, then at my active duty orders. 2 narratives, 1 visual, 1 documented. He closed the folder slowly. Miss Grant. He said if you are asserting that the court's commentary reflects unfair presumption, you are welcome to make that argument formally. Formally, not emotionally, not defensively, formally. My parents shifted in their seats. They didn't like where this was going. The plaintiff's attorney crossed his arms again, but less confidently. The judge adjusted his glasses. For now, he said the court will take the petition under advisement. Under advisement meant nothing immediate, but the record was set. The comments were recorded, transcribed, preserved. I looked directly at the bench. Your Honor, I said evenly. For clarity, I would like the record to reflect each statement equating my part-time employment with diminished fiduciary capacity. Silence. The court reporter's fingers hovered above the keyboard. The judge's expression changed just slightly. Are you challenging the court's impartiality, Miss Grant? He asked. I held his gaze. I am requesting accuracy in the record. I am requesting accuracy in the record. The judge held my gaze a second longer than necessary. Accuracy, he repeated. Yes, Your Honor? Because accuracy determines whether this proceeding evaluates evidence or optics. The courtroom went still. The plaintiff's attorney shifted in place. He knew what was happening. He just didn't like that it was happening in open court. The judge leaned back slightly. Very well. Clarify your position, Miss Grant. I picked up the document I had placed on the table earlier and stepped forward. Your Honor, I am Captain Olivia Grant, United States Army. I serve as a judge advocate. This time I said it without qualifying language. No build-up. No dramatic pause. The words landed clean. The court reporter looked up briefly before continuing to type. The plaintiff's attorney blinked. My father stopped smiling. The judge looked down at the orders again. You are currently on active duty. Yes, Your Honor. You did not previously introduce yourself as captain. You addressed me as Miss Grant. I responded accordingly. A few restrained smiles flickered across the room. The judge's jaw tightened almost imperceptibly. What is your current assignment? I advise commanders on legal compliance, administrative investigations, financial liability matters, and statutory interpretation. I also handle service member estate advisement when required. The plaintiff's attorney stepped forward quickly. Your Honor. Military advisory work is not synonymous with private estate administration. It is synonymous with fiduciary responsibility, I said evenly. He stopped. I continued. As a judge advocate, I am entrusted with advising on matters involving federal property regulatory compliance and financial exposure exceeding the value of this estate. I am subject to periodic background investigations, financial disclosure, and ethical review. The judge asked, what level of clearance do you hold? Secret, Your Honor. With active reinvestigation completed within regulatory timeline. That was enough detail. Not classified, not dramatic, just structured. The plaintiff's attorney tried to pivot. Regardless of military credentials, the respondent is currently employed in a coffee shop. Yes, I said. 3 shifts per week, during transitional leave between assignments. And you believe that reflects sound fiduciary judgment. I believe lawful employment reflects responsibility, not instability. The judge interjected. Captain Grant, Why not disclose this background at the outset? Because the petition challenged my capacity based on assumptions. I allowed the plaintiffs to present their full argument. The judge's expression sharpened. You allowed? I did not interrupt, Your Honor. I responded when asked. The silence in the room felt different now, less amused, more alert. My parents were no longer relaxed. The plaintiff's attorney cleared his throat. Your Honor, we are not contesting her patriotism. We are contesting the decedent's decision. That decision, I said calmly, was made after consultation with independent counsel. The judge looked at me carefully. You are aware that suggesting judicial bias is a serious matter. Yes, Your Honor. And yet you requested the record reflect my commentary. Yes. Why? Because equating lawful service employment with diminished fiduciary capacity creates a presumption unsupported by statute. The plaintiff's attorney objected again. Argumentative. The judge didn't immediately rule. Instead, he asked me directly, are you asserting that this court has acted improperly? I answered without hesitation. I am asserting that the court's comments may reasonably be interpreted as prejudicial. That sentence changed the air. Not loud, not dramatic, but final. The court reporter's typing became noticeably sharper. My attorney stood beside me now. Your Honor. We moved to preserve the record of statements equating part-time service employment with incompetence. The plaintiff's attorney protested. This is theatrics. No, my attorney replied evenly. It is procedure. The judge removed his glasses and placed them on the bench. He looked at me for a long moment. You understand the implications of what you are doing? Yes, Your Honor. My father leaned forward slightly. My mother's hands were clasped tightly in her lap. The judge exhaled slowly. This court does not tolerate allegations of bias without foundation. Understood, I said. Then be precise. I am requesting the court clarify whether my employment status alone is being used as evidence of incapacity. The judge didn't answer immediately. He looked at the monitor again, still showing the image of me in an apron. Then he looked at the bar certification. Then the active duty orders. 2 versions of me. 1 visual, 1 documented. He straightened. The court's remarks were observational, not prejudicial. Respectfully, I said, observations carry weight when made from the bench. The plaintiff's attorney shifted again. Your Honor, this is becoming unnecessary. No, the judge said sharply, surprising everyone. He looked back at me. Captain Grant, if you believe the court's commentary compromises impartiality, you are free to file the appropriate motion. There it was. Not an invitation. A line drawn. My attorney didn't hesitate. Your Honor. We move for recusal. The word dropped heavily. Recusal. The courtroom reacted instantly. Whispers. Movement. My father's face went pale. The plaintiff's attorney stepped forward aggressively. This is outrageous. My attorney stayed composed. The record reflects commentary linking lawful employment with incapacity. We are preserving the integrity of the proceeding. The judge's expression hardened. You are formally requesting that I withdraw from this case. Yes, Your Honor. Silence spread again. The judge looked at me one last time. Captain Grant, he said slowly, you understand this action escalates the matter. I understand that impartiality must be unquestioned. No sarcasm, no anger, just fact. The judge gathered the documents in front of him and closed the folder. This court will take the motion under review. He struck the gavel lightly. Recess. The sound echoed sharper than it should have. People stood quickly. Conversations erupted in low tones. My parents remained seated. My mother looked at me like she'd just realized the narrative had shifted. Not because I served coffee, but because I knew exactly how courtrooms work. I picked up my folder calmly. The image of the apron was still on the monitor. No one was laughing anymore. I walked out of the courtroom without looking at my parents. The hallway felt narrower than it had that morning. Lawyers were already whispering. Word travels fast in a courthouse, especially when someone moves for recusal in open session. My attorney didn't waste time. We file immediately, he said. Today. Yes. A motion to recuse isn't emotional. It's procedural. You cite the record. You reference specific language. You explain why a reasonable person might question impartiality. Not that the judge is corrupt, not that he's incompetent, just that the appearance of bias exists. Appearance. That word had worked for them earlier. Now it worked for us. By the end of the afternoon, the transcript request was submitted. We highlighted exact statements. Managing millions is a bit different from serving coffee. This court deals with serious estates, not part-time cafe workers. Service position not typically associated with high-level financial administration. On their own, they sounded observational. In context, they built a narrative. The plaintiff's attorney filed a response within 48 hours. Predictable language, mischaracterization, judicial discretion, defendant overreaching. Interesting choice. The recusal hearing was scheduled quickly. Judges don't like motions hanging over their docket. When we returned, the courtroom was quieter. No monitor this time, no photos, just transcript excerpts and procedural arguments. My attorney stood first. Your Honor, this motion is not personal. It is structural. The record reflects repeated linkage between lawful employment and diminished fiduciary capacity. The standard is not actual bias. It is reasonable perception. The plaintiff's attorney responded immediately. The court's remarks were contextual. Respondent is attempting to weaponize commentary. Weaponize, as if procedure were aggression. The judge listened without interruption. He didn't defend himself emotionally. That would have made things worse. He asked precise questions. To counsel for respondent, are you alleging that this court cannot fairly evaluate the evidence? We are alleging that the commentary creates reasonable doubt regarding impartiality. To counsel for petitioners, do you dispute the language in the transcript? No, Your Honor. We dispute the interpretation. That was honest. No one denied what was said. They just disagreed on what it meant. The judge removed his glasses again. He looked directly at me. Captain Grant, do you believe this court has treated you unfairly? The question wasn't procedural. It was personal. I answered carefully. I believe the commentary may influence how the evidence is perceived. He held my gaze for a moment. Then he nodded once. The room stayed completely silent. No shifting, no whispering, just air. He spoke evenly. The integrity of the judiciary depends not only on actual impartiality, but on its appearance. The plaintiff's attorney stiffened. The judge continued. While this court does not concede bias, it acknowledges that certain remarks may be construed as reflecting predisposition. Conceding without conceding. That's how judges do it. He folded his hands. To preserve confidence in these proceedings, this court will grant the motion for recusal. There was no gavel this time. Just a statement. Granted. My mother inhaled sharply. My father leaned back in his seat like someone had just miscalculated a business deal. The plaintiff's attorney tried one last effort. Your Honor, with respect, this creates unnecessary delay. Delay is preferable to doubt, the judge replied. That was the final word. The case would be reassigned. Different bench. Different evaluation. Same evidence. Outside the courtroom, the hallway energy felt different than before. No whispers this time. Just quiet recalibration. My attorney handed me a copy of the order. Good work, he said. I didn't do anything, I replied. You stayed precise. That's doing something. Across the hall, my parents were speaking urgently with their attorney. Not angry. Concerned. Concern is louder than anger when money is involved. For weeks, their strategy had relied on narrative. Coffee shop. Apron. Optics. They had expected a judge who nodded along. Instead, they now had a clean slate, which meant they'd have to argue facts. The reassignment happened faster than expected. The new judge was known for procedural rigidity and minimal tolerance for theatrics. That reputation circulated quickly. The plaintiff's attorney requested a scheduling conference. We agreed. Inside the new courtroom, there was no small talk, no commentary. The judge reviewed the file in silence for several minutes before speaking. This matter concerns the validity of a will, she said. The question is capacity and undue influence, not optics. That was the first sentence she spoke in the case. It was enough. She continued, counsel will limit arguments to statutory standards and evidentiary support. Commentary regarding employment optics is irrelevant unless directly tied to fiduciary incapacity. The plaintiff's attorney nodded carefully. My attorney simply said, understood. The judge looked at me briefly. Captain Grant, you are representing yourself substantively with advisory counsel. Yes, Your Honor. Very well. Then we proceed on evidence. No amusement, no smirks, no side commentary, just process. Outside, my parents looked unsettled. They hadn't lost yet. But the room no longer leaned in their favor. The story about the waitress had lost its leverage. Now it would come down to documents, medical records, attorney testimony, witness credibility, which is where things become less entertaining and more decisive. As we left, my father walked past me without speaking. My mother hesitated for half a second. You didn't have to embarrass him, she said quietly. I looked at her evenly. I didn't. There wasn't much else to say. Inside the new courtroom, the monitor remained dark. No apron, no coffee mugs, just binders, and a judge who didn't laugh. I opened my binder and stood when the clerk called the case again. No monitor, no photos, just a clean bench, and a judge who had already read everything twice. The plaintiffs went first. Their attorney abandoned the coffee shop narrative entirely. No apron, no employment commentary. Now it was all about concern for my grandfather's capacity. He called the family friend again. This time the testimony sounded thinner. Did Colonel Grant ever express confusion about his assets? The judge asked directly. Number. Did he ever indicate he did not understand the contents of his will? Number. Did you witness the will being executed? Number. The judge made a note and moved on. The plaintiffs then tried to suggest isolation. Was access to the decedent restricted? Their attorney asked. The witness hesitated. Olivia handled most of the logistics. Logistics meaning doctor appointments, scheduling, bills. So she ensured his affairs were organized. Yes, the word hung there. Organized, not manipulated. Organized. The plaintiff's attorney shifted strategy again. He called the drafting attorney who had prepared my grandfather's final will amendment. A sharp man in his 70s who looked mildly annoyed to be there. Did you evaluate Colonel Grant's mental capacity at the time of execution? The judge asked. Yes. And he was fully competent. Did anyone else participate in drafting instructions? Number. Did Captain Grant influence your drafting? Number. The plaintiff's attorney tried to press. Was Captain Grant present during discussions? Occasionally. And did she suggest terms? She asked clarifying questions regarding tax implications. That is not undue influence. The judge didn't react outwardly, but her pen paused again. The plaintiffs rested their case without theatrics. No drama, just a quieter version of their original suspicion. My attorney stood and nodded toward me. I handled the evidentiary presentation. Medical records confirming cognitive clarity. Bank statements showing no irregular transfers. Email correspondence between my grandfather and his estate attorney discussing revisions in precise language. Then I submitted my active duty service record and bar certification, not as spectacle this time, but as context for fiduciary competence. The judge flipped through each document deliberately. No commentary, no jokes, just review. She asked one question that mattered. Captain Grant, do you understand your fiduciary obligations as executor and primary beneficiary? Yes, Your Honor. Define them. Duty of loyalty, duty of care, duty to act in the best interest of the estate, duty to avoid self-dealing unless expressly authorized. Do you intend to retain independent financial advisors? Yes. Have you already consulted one? Yes. She nodded once. No visible reaction. The plaintiff's attorney made a final attempt. Your Honor. While competence may not be disproven, the appearance of imbalance remains troubling. Appearance, the judge repeated flatly, is not a statutory standard. That was the cleanest dismissal of the word I'd heard in months. Closing arguments were brief. The plaintiffs argued emotional fairness. We argued legal validity. The judge didn't deliberate long. She reviewed her notes, adjusted the stack of papers in front of her, and spoke clearly. The court finds no evidence of undue influence. My mother's shoulders stiffened. The decedent was competent at the time of execution. My father's jaw tightened. The will was drafted by independent counsel, properly witnessed and executed in accordance with state law. Silence. The petition to invalidate the will is denied. It wasn't loud. It didn't need to be. The estate shall proceed under the terms outlined in the document. The plaintiff's attorney stood quickly. Your Honor, we request. Denied, she said without raising her voice. She looked directly at him. There is no basis for supervisory control. Another quiet blow. Then she added something neither of my parents expected. Given the absence of evidentiary support and the burden imposed on the respondent, the court orders petitioners to bear the legal costs incurred in this challenge. That one landed harder than the rest. Legal fees in contested probate cases are not symbolic. They are substantial. My mother's face went pale. My father leaned forward slightly, then stopped himself. The judge closed the file. This matter is concluded. She stood. The clerk announced adjournment, and that was it. No applause. No dramatic music. Just the sound of chairs moving. My attorney placed a hand lightly on the table. You handled that well, he said. I nodded. Across the aisle, my parents remained seated, not devastated, just stunned. Their attorney leaned in, speaking quickly and quietly. Damage control. They hadn't just lost the inheritance. They'd lost the narrative. They couldn't say I manipulated him. They couldn't say I was unstable. They couldn't say I was incapable. The record didn't support any of it. As I gathered my binder, my mother finally stood and approached. Not aggressively, not warmly, just uncertain. "This didn't have to happen," she said quietly. "It already did," I replied. My father joined her. "You could still handle things differently," he said. "Meaning settlement, meaning redistribution, meaning voluntary correction." I looked at both of them. "For years you assumed I wasn't capable," I said calmly. Today the court disagreed. Neither of them responded. There wasn't much left to argue. Outside the courthouse, the afternoon felt strangely normal. Traffic moved. People crossed streets. Coffee shops were open. My phone buzzed with a notification from my security manager. Update received. No impact to clearance. Clean. Complete. Professional. I stood there for a moment, not feeling victorious. Just steady. My parents walked past without speaking again. The legal battle was over. But clarity doesn't automatically repair relationships. It just removes illusions. I adjusted my jacket, stepped down the courthouse steps, and walked toward my car. I unlocked my car but didn't get in right away. The courthouse doors closed behind me, and for the first time in months, there was nothing pending. No motions, no hearings, no transcripts to review, just outcome. My phone buzzed again. A text from my mother. "We should talk, privately." I stared at it for a second, then locked my screen. I drove home instead. The estate paperwork moved quickly after the ruling. Once the petition was denied, the procedural barriers disappeared. Accounts transferred. Titles updated. Investment portfolios unlocked from temporary restriction. $5.2 million sounds dramatic when read in a courtroom. On paper, it's line items: real estate equity, retirement accounts, brokerage holdings, municipal bonds. Not flashy, just disciplined accumulation. Exactly the way my grandfather would have structured it. I hired an independent fiduciary advisor immediately. Not because I doubted myself, but because stewardship isn't ego-driven. It's structured. First step, audit everything. Second step, reduce unnecessary exposure. Third step, establish long-term management strategy. No impulsive spending. No revenge purchases. No look-at-me-now moments. That kind of behavior proves the wrong people right. 2 weeks after the ruling, my father called. Not to apologize, to negotiate. "We don't want things to stay like this," he said. "They don't have to," I replied. A pause. "Well," he continued, "you could reconsider the distribution. For the sake of family." Family. The word felt different now. "I'm honoring the will," I said evenly. "That will was emotional," he replied. It was deliberate. Silence. "You're really not going to adjust anything." Number. He exhaled sharply through his nose. "So that's it. That's it." I ended the call calmly. Not angry, not shaking. Just finished. My mother tried a softer approach a few days later. "We made mistakes," she said. "But taking everything, it feels extreme." "I didn't take anything," I replied. "I received what was given." Another pause. "You don't have to prove anything anymore," she said. That one almost made me laugh. This was never about proving anything, I answered. It was about accuracy. She didn't respond. There was nothing else to debate. The legal fees were processed through the court order. Their attorney billed them directly. Consequences look different when they arrive as invoices. A month later, I returned to duty at my new assignment. Back in uniform, back in briefing rooms where people don't care about family drama. The security office confirmed everything was closed cleanly. No flags, no adverse notes, no lingering issues. My commander pulled me aside after a meeting. "I read the case summary," he said. "Yes, sir. You handled it professionally." "Thank you, sir." He paused. "You're aware you didn't have to push for recusal?" "Yes, sir." "Why did you?" "Because record integrity matters." He nodded once. "Good answer." Work resumed like it always does. Advising commanders. Reviewing investigations. Counseling young service members who made expensive mistakes at 19. And something started happening quietly. Word spread. Not publicly, not in headlines, but among soldiers. A specialist asked if I had time to review a probate issue involving his grandmother. A staff sergeant asked about beneficiary rights after a messy divorce. A captain came in embarrassed because her parents were pressuring her to co-sign a risky loan. Patterns repeat. Family doesn't automatically mean aligned interests. I used part of the estate to establish a small legal assistance fund. Nothing flashy, nothing branded with my name. Just a reserve that allowed junior enlisted service members to consult civilian probate counsel when needed. No press release, no announcement, just structure. One afternoon, months later, I stopped by Lauren's cafe in uniform. No apron, just coffee. She handed me the cup and smiled. "You don't look unstable today," she said. "Must be the caffeine." We both laughed. The irony wasn't lost on me. The same hands that carried coffee carried classified files. The same person, different assumptions. I drove home that evening and checked the estate portfolio one more time before closing my laptop. Steady growth, structured management, no drama. My parents stopped calling after a while, not because they understood, because they realized negotiation wasn't happening. Distance settled naturally, not explosive, not hostile, just firm. A few extended relatives reached out occasionally curious about what really happened. I kept it simple. The court reviewed the evidence. That answer usually ends the conversation. Sometimes, clarity is the most uncomfortable outcome for people who prefer narratives. I don't hate my parents. That surprises people when I say it. I just don't rely on them. There's a difference. Trust isn't automatic because biology says it should be. It's earned. My grandfather understood that. He didn't leave me money because I was family. He left it because he trusted my judgment. The courtroom laughter didn't change that. The apron didn't change that. The recusal didn't change that. And the final ruling simply confirmed what had already been decided long before anyone filed a petition. One evening, I stood in my living room looking at the framed photo of my grandfather in uniform. Colonel James Grant, arms crossed, expression steady. He would not have celebrated. He would have asked one question. Did you earn the room? I thought about the judge who laughed, the judge who didn't, the transcript, the record, the ruling. Yes. I turned off the lights and headed to bed. There was nothing left to argue, and nothing left to prove. If there's one thing this whole inheritance dispute taught me, it's this. Most people don't misunderstand you by accident. They misunderstand you on purpose because your reality doesn't fit the version of you they're comfortable with. In that courtroom, when a judge called me just a waitress, it wasn't really about coffee. It was about assumption. It was about how easy it is to reduce someone to the most convenient image available. Apron equals incapable. Service job equals unstable. Young woman equals inexperienced. That narrative almost worked until it met the record. The truth didn't need drama. It needed documentation. Becoming a JAG officer didn't make me better than anyone in that room. It just meant I understood something very clearly. Credibility isn't volume, it's structure, it's preparation. It's knowing when to speak and when to let assumptions overextend themselves. Winning the case wasn't the biggest victory. Keeping my integrity intact was. I didn't walk out of that courtroom feeling powerful. I walked out feeling aligned. Aligned with the way my grandfather raised me. Aligned with the oath I took. Aligned with the person I've chosen to be. Some relationships don't survive clarity, and that's okay. Not every battle is about proving someone wrong. Sometimes it's about refusing to shrink so others feel comfortable. And sometimes the quietest answer is the strongest one. If this story about a courtroom humiliation, a $5.2 million inheritance dispute, and revealing I'm a U.S. Army JAG officer resonated with you, consider subscribing to the channel. I share real stories about military life, family conflict, legal battles, and what it actually means to stand your ground without losing your professionalism. No drama for clicks, just clarity, accountability, and the truth behind the headlines. If that's your kind of content, I'll see you in the next one.